This section of what I'm going to talk about is equally, if not more important, dispute resolution. So just to start off, this is why talking about dispute resolution is so important. So again, going back to the cost of justice report, this is a report just from 2018, so just last year. $10,000 and 98 is the average that's spent on trying to solve legal problems by people who appeared in court. And half of that amount, about $5,500, is the average people spend on legal problems by people who did not appear in court. So going to court is very, very expensive, especially if you have counsel. This report also had numbers on differences in costs of resolving disputes where people were represented by a lawyer and where they were not. And it's similar to these numbers. It's about $10,000 as opposed to $5,000 if someone has a lawyer versus someone who doesn't have a lawyer. And the reason I bring that up is just to say that it's very, very important to inform people that it's not appropriate to automatically go to court to resolve their disputes. It can often increase conflict and kind of derail the whole process. Family court is in the same courthouse. It's the same court system that people use for their other matters. It's the same court system that we have for insurance claims, for IP matters, for personal injury. There isn't a special family court system that operates differently. So it is a very adversarial system with one person on one side arguing one thing, another person on the other side arguing something opposite. And going there can sometimes fuel the fire between parties who are already in conflict. So it's really important that people try whatever out-of-court options are available to them and only use court as a last resort if they really just can't agree. In the Family Law Act, one great thing that we're seeing is a huge emphasis on support for dispute resolution processes outside of court. The government, the courts, lawyers, everybody is pushing for more dispute resolution outside of court in the area of family law. An important thing to remind clients of is that even if they're not in court, they still have a duty to make full and frank disclosure. Disclosure is often a huge hurdle to getting things resolved, so much so that courts have actually called it the cancer of matrimonial litigation. Someone could be not forthcoming about their assets or hiding assets in other countries, or they're saying, I'm only making $10,000 a year, but really they're earning money under the table from whatever. So it's really a big barrier to getting things resolved in a timely and efficient manner. And just because parties aren't in court, they need to know that they have the same obligations to make disclosure as parties that are in court. There's also a lot of support for agreements, especially agreements on property and spousal support. The only way to get an agreement set aside is to prove that it's significantly unfair. Under the Family Relations Act, the old act that we had before, all you had to do was prove that it was unfair. And to, normal, non-legal people, the difference between significantly unfair and unfair might not really seem that important. But in legal terms, it's really, really important because it places a much higher burden on the person seeking to set an agreement aside, and it makes agreements that parties enter into more protected, which is a good thing because we want people to be able to rely on agreements that they make, on arrangements that they choose to make that are different from what the Family Law Act provides. So here I've set out some dispute resolution options for people, and I won't go into each of them in very much detail. There are people who do whole presentations on out-of-court dispute resolution options. But generally, the first one is always negotiation. And this can be done with lawyers or without lawyers. Often parties who are pretty amicable, who maybe didn't have a super emotional separation or a super high conflict separation can work things out between them just by talking to each other, just by sitting down and having a coffee and maybe even having a neutral third party, like a mutual friend there to try to help move things along without things getting too emotional. We always encourage parties, as soon as I get a client, I always make sure to let them know, to give them some communication guidelines for communicating with their ex-spouse, such as make sure all your communication is very businesslike. Just talk about matters that involve your children. You don't really need to talk about anything else. If you're already in court on other issues, for example, don't send an email when you're in the heat of the moment and you're angry. Maybe sleep on it. Just kind of common sense stuff, so that you can ensure that communication between people is as productive as possible. Mediation is a tool that we use in almost every case we have. In the Supreme Court process, you can actually compel parties to go to mediation by serving them with a notice to mediate. But a lot of people just choose to attend mediation because it's a much more cost-effective way of trying to resolve disputes than going to court and having lawyers. So basically that's it's a structured session with a trained neutral third party who helps facilitate discussions that parties have and helps them try to reach a consensus on their issues. So one of the benefits to mediation is that people have complete control of what they're agreeing to, instead of going to court and having no idea what a judge may order. You're completely in the hands of the court, and they may order something that you don't like. In a mediation, you retain agency over the decisions that you're making in your family law matter. A mediator cannot order you to do anything. They can only help you enter into arrangement where you both agree. I often find that parties who enter into mediated agreements are much more likely to follow those agreements than if they haven't been an active role and participate in making those decisions. So it makes agreements stronger as well. Sometimes it doesn't always work. And sometimes in a case, there are issues that are much more contentious than other issues. For example, the parties may not really have a lot to argue about when it comes to property division, but when it comes to parenting, they're completely opposed, and that kind of sets the smoke signals up right away when you start talking about those issues. So sometimes mediation is used just to help parties resolve some of the less contentious issues, and it takes some issues off the table before going to court, which is a really good thing, because the less issues that are in play in the courtroom, the cheaper and more efficiently people can resolve their disputes. So they're kind of ranked from least to most intensive. So moving sort of left to right, the next one is mediation-arbitration. So that is when people will start off with a mediator who will try to get them to reach a consensus. And if that fails, then the mediator takes off their mediator hat, puts on an arbitrator hat, and is then in a position to make a binding decision on the parties. So they have a similar role to a judge, but it's still an out-of-court process. Parties will hire an arbitrator and enter into a contract with them that sets out the terms of how they're going to resolve the dispute. So parties could agree that we want lawyers to make submissions, we want to be able to cross-examine each other, or they could agree to a different process. But the difference between arbitration and mediation is that an arbitrator can make binding decisions. One reason why people use arbitration is that in light of the long wait for trial dates, it's often a faster way to resolve disputes, and people have a little more control over what the process looks like, whereas if you go to court, it's always the same process for everybody. It's very, very popular in Alberta and Ontario. It's not used as much in BC, but it's gaining popularity, and it's still a really good option for people, and often ends up being a lot cheaper as well. Collaborative law is a relatively new process where parties are each represented by a lawyer, and the lawyers do most of the negotiating. But the key element of collaborative law is that both parties sign a contract that if they want to go to court, they have to get a new lawyer. So it's a process that takes place entirely by negotiation, sometimes with the use of other professionals like mental health professionals, accountants, if it's a complex financial file, things like that. But that's kind of the carrot that collaborative law tries to get people with, is that you have to get brand new counsel who's not familiar with the file and go through that whole process again if you want to take this matter to court. And then, of course, litigation is always open to people, and it is a useful tool and sometimes necessary to resolve a dispute. But wherever possible, we always say to people that it's so important to try all the other options that are available to you to resolve the dispute, and there are so many short of going to court, and using it really as a last resort instead of all of a sudden jumping on the wagon, filing your application the day after separation, which can really just make things go off the rails. I've seen it time and time again. I was very happy to hear in the first presentation we had, a couple people mentioned that their organization offers unbundled legal services. So I'd just like to put in a special word about that. So this is a type of dispute resolution where lawyers are involved, but a lawyer is only involved for part of the dispute. And it's usually the part that the client has the most difficulty with, maybe the one that involves the most legal analysis that isn't really straightforward. Like the representative from Material Women's Center was talking about helping someone who had an evidentiary issue, that there was a lot of legalese and they didn't really know how to navigate it. That is a perfect example of an unbundled service. I provide unbundled services. Not all lawyers do, but it's really important to inform clients that if they're thinking about hiring a lawyer, this is something they should be asking for if they have limited income. So I always make sure to ask clients right from the get-go in the initial consult, what is your budget for legal fees? Because some people are only have a certain amount to spend on legal fees. Some people are only willing to spend a certain amount on legal fees and they're not comfortable with anything higher than that. And for people whom that amount is lower, a full representation lawyer is not going to help them. They're going to review all their documents, maybe attend a mediation, and then the client will run out of money and they won't have gotten much value out of that. So, I'm moving ahead of myself. So with unbundled services, some of the things that lawyers often provide, and that I provide a lot in my own practice, are drafting court documents, so drafting notice of family claim. If the parties aren't in court yet, sometimes drafting a lawyer to the other party, or drafting a letter to the other party or the other lawyer, setting out what that client wants, what their position is. Sometimes we have more of a legal consulting arrangement where the client is in court, they're doing things by themselves, but sometimes they have questions. The other lawyer sends them a letter and they have no idea how to respond. So they'll just send me an email or call me and I can help them navigate that situation. Sometimes it's giving advice on how to present yourself in court, when to stand up, when to sit down, how to refer to the judge, what to bring to court, what to provide to the other party. Services like that are really, really helpful for people who can't afford to fully retain a lawyer. So it's important, and not everyone knows this, but it's not just black or white. Either you have a lawyer who does everything or you are all on your own. There is an option to enter into these unbundled or limited service retainer agreements so that you can just get help for the things that you really need. There's a new website from the People's Law Society called unbundlinglaw.ca. It's very new. It just came out within the past couple months, and it includes a roster of lawyers who provide these services in family law. So if you have someone who is looking to hire a lawyer but has maybe a more limited budget but doesn't qualify for legal aid, they're kind of in that weird middle ground where there isn't really a service that like a free service that can help them, then I really encourage you to check out the family law roster. There's dozens, if not hundreds, of lawyers on there. You can find one in your area or in the client's area that you can make a referral to.